Hey, good morning, good afternoon, good evening. This is Michelle in the background. Something's going on with my camera, but I want to move on in our class. So this is going to be about agency creation, and this can be in any state. This is the real estate for those who are taking the real estate exam. Some of this is specific to Maryland, but most of this is for the whole country. Okay, so don't let the state intimidate you or keep you from learning here. This is going to be about agency relationship as our next state. Is our next subject. All right, let's talk about types of agreements that create agency, because that's where we left off. Now, I have my real estate license already in Virginia, but I was going to take it for Maryland too because I'm in both states. So that's why I'm taking Maryland, but I've already passed the test in Virginia. All right, and let's go over some of this. Just remember that this is not necessarily Maryland. Generally speaking, as far as you'll need to know for your national exam, you can create an agency relationship through express agreement or implied agreement. With an express agency, you and your client agree to understand the relationship. Now, if you need to go back and look at some of the previous videos that we did in this series, then feel free to do that. I'm not going to keep going back and reviewing that because it's not fair to the people that have been doing this series. And it's also going to take too long. I mean, the videos are going to be ridiculously long. And remember, when we learn, we need to learn by seeing. We need to see it, we need to hear it, and we need to write some things down. And that's how you will remember. So that's how you keep reviewing these videos if you need to. It will help you remember more for the test, because that's what we're studying for, the test. Express agreements can be written or unwritten. However, written express agreements are ideal. You always want to try and get things in writing, and most brokerages will want you to get everything in writing. They establish an agency relationship because they write out the duties and responsibility for you and your client, and this allows you and your client to understand what is expected. You and your client may enter into an agency agreement, the listing contract, the buying agreement. Let's say you want to go buy a house. You need to have somebody represent you. Why do you need somebody to represent you? Can't you just go up there and buy it yourself? You know, I mean, these people might be trying to rip you off. You don't know what they're doing behind your back. That's why you always want to have somebody on your side that can look up things and make sure they're following the law and make sure you're getting the best deal. You're representing a seller and a potential buyer want to make an offer on your seller list. You assist the buyer by presenting the buyer's offer to your seller. During the prior discussions with the buyer, if you fail to disclose something that represents the seller, the buyer assumes you're negotiating the offer on their behalf. In this example, it could be implied that you're acting as an undisclosed dual agent, which means you're representing the buyer and the seller. And as a result, you may be subject to disciplinary actions if you do not make that notice up front. Okay, in my state, agency agreements must be in writing for the agreement to be enforceable. And I think in Virginia, it's also the same way. They always like everything in writing because if you have a problem and you get taken to court, you have it in writing that we are representing you. Reduce your risk. Because of your responsibility to provide fiduciary duties to your client, either express or implied, you must be very careful with your actions. For your national exam, you'll need to know that if you create an implied relationship, it's found that you didn't provide fiduciary duties, you could be held liable. Okay, so that's one of the reasons why we like to have things in writing. Follow these guidelines to reduce your risk of implied agency and undisclosed dual agency. Make sure your firm's policy on agency and dual agency are clear, including the disclosure requirements. Clearly understand and communicate your fiduciary students as an agent. Before acting in a way as an agent, secure an express agency agreement in writing. If you're engaging in a dual agency, ensure you have all the parties' written consent. That means you need to represent both of them, honestly, and you want to do that anyway, regardless if they even sell anything. You don't want to go around getting the reputation of ripping people off. It's not good seeds to sow. You want to have a good reputation so you can get more clients, and so that people will refer you to other people and you can get some more sales. Provide all your parties with the proper disclosures. All right, let's take our test here. An agency relationship that is understood and agreed by both parties. Is that implied? An agency relationship that exists because you behave in a way that leads consumers to believe they're your agent. So I think that's implied. Let's check it. Yes, okay. So if you're taking a snapshot here of the screen, there you go. An agency relationship that is understood and agreed by both parties is express. And if you're just acting a certain way in a behavior, it's implied. If you need any of these resources, you can contact me on my website, which should be noted in the comments below. In case I forget, I'll try and put that in there. Contact me on my website by the contact page, and we could give that to you for free of charge. All right, did you get that in writing? You define implied and express agency in the last interaction. Let's go a step further and see if you can recognize them. Read each scenario and determine if it's an example of implied or express. Okay, we have our little resource over here if we need it. We have about 3 questions. Let's go. You receive a call from a friend of a friend. He'd like you to show him some condos this weekend. After a few options, he decides to make an offer, which you help present to the seller. All right, well, he didn't sign anything. Okay, so I want to say it's implied. A few years ago, you helped Renee buy a new house. Her parents have decided they'd like to downsize now that the kids have moved out. You meet with them to tour the property, but they are so pleased with how you worked with Renee, they signed an agency agreement before you left. Okay, let's read this again. A few years ago, you helped Renee buy a new house, and her parents decided they would like to downsize now that their kids have moved on. Okay, you meet them at to tour the property, and they are so pleased with how you worked with Renee, they signed an agency agreement. So I would say this is express. Fresh out of college, a young man walks into a brokerage office. He'd like some help finding a new apartment. After chatting about what he's looking for, how he liked to work together, he signs an agency agreement and then heads out to meet some buddies for lunch. So I would say it's an express. Let's see if we're correct. Okay, so anytime they sign anything, it looks like it's express, okay? If they don't sign anything, it's just implied. Okay, if anybody wants to take a screenshot of any of these to help them, that would be fine. Okay. Avoiding implied agency. We just mentioned that one way to avoid implied agency is to recognize what it is. And what is another way to avoid an unwanted implied agency? I would say this one. Let's see if we're right. Yes. It is best to get an agreement in writing before performing any actions. Stop. Let's look at how someone may agree to agency after the fact, or how, without even a written agreement, there may be proof there was an agreement. We're talking about ratification and estoppel. Okay. In these terms, let's identify what they mean. Okay, ratification is acceptance after the fact, sometimes in contrast to a prior agreement. Ratification may occur through contractual paperwork or the party's action. The doctrine of estoppel is a legal doctrine that says a person is stopped from asserting rights or facts that aren't consistent with a previous statement, position, or behavior. Let's do an example to help us understand this. A buyer wants the seller to leave behind the washer and dryer, but the seller takes the appliances instead of leaving them. The buyer can ratify the seller's actions after closing by occupying the house without complaint and perhaps telling the seller, "That's fine, I wanted a new set anyway," and then purchasing a new set. Because of those actions, the buyer ratified the seller's behavior. The buyer couldn't later decide to sue the seller by stating that he didn't accept the situation. The doctrine of estoppel is in action. What do these terms have to do with agency? Let's look at an example. A buyer may state that he doesn't want you as his agent. He simply wants you to show him a house, which does happen. Let's just say you're looking at houses and you don't want to sign an agreement. You haven't made a decision on where you want to even live. But then he asks you to show him several houses and eventually signs a buyer agency with you. But the buyer has ratified the role you played as his agent. So he ratified what he originally said because he didn't originally want an agent and then he signed it. Let's look at another situation. Suppose you have no agency agreement with a buyer and Todd, nor have you expressed interest in either writing or verbally your relationship with him. Then you assist Todd with a property purchase. You negotiate for him, you advise him, and you treat him in all ways as a client. Because of your actions, you effectively ratified your relationship with Todd by continually to perform fiduciary tasks on his behalf. This is very dangerous for several reasons, because if you screw up, he could sue. And another reason is you want to make sure you get paid. If you don't have nothing in writing saying you're the agent, you might not even get paid, so you want to make sure you try and get these things in writing. All right, excuse me 1 minute, I got a cough. Okay, so what if later it's discovered that you told the seller that Todd was willing to pay more, which resulted in him spending more than he might have otherwise? The doctrine of estoppel would apply. You can't now claim that you weren't acting in an agency capacity for Todd. Another example of estoppel that you might see in your real estate career occurs when a buyer is purchasing an unoccupied rental property. Existing tenants may be asked to complete estoppel statements or certificates to verify the amount of rent they are paying. This prevents either the buyer or the seller from later claiming that the rent payments were more or less than the amount stated previously. Estoppel statements, okay. All right. This is the first time I've heard of this, actually. It rarely ever comes up. Okay, acceptance after the fact, either through paperwork or actions. Is ratification. Okay, prevention of a legal claim that is contrary to the person's actions is estoppel. Okay, if you're taking a screenshot, you might want to get ready and take it. And there you go. So that makes it a little easier to understand than just reading it off of these resources. Okay, does the scenario resemble a ratification or estoppel situation? All right, the sellers left some storage shelving in the basement after they moved out. They purchased new ones, but then asked the buyers to let them in to retrieve the shelving. They left. The buyers refused. The sellers threatened to sue, but their lawyer advised them they couldn't. All right, I think it's ratification. Not positive, but let's see. A seller agreed to leave a painting the buyer liked. And as moving day approached, however, the seller was having trouble parting with her uncle's painting, so she took it with her. Then she contacted her agent to see if she could provide the monetary value of the painting instead of leaving the painting. An addendum to the contract was created. I might have these backwards, but let's try it. Yes, I have them backwards. Okay. So this one would be estoppel because the lawyer advised them they couldn't. The sellers threatened to sue. So you're changing legal stuff. This one here is just a ratification about a painting. Yeah, it's a little tricky. Sure is. All right, there you go. If you need a screenshot, there's your screenshot. All right, an agency scenario. Do we want to do this on the next slide? Okay, no, we're still on implied and express, so we'll keep going. All right, looking to build your business? You've been calling on local homeowners who are trying to sell their homes without the help of a real estate agent. You scored a meeting with one owner who has a home in a desirable neighborhood, but it's been on the market longer than you expect. Is it priced right? Is the homeowner willing to negotiate? The homeowner travels for business but doesn't want someone he's never met showing the house. So he requests to meet the agents prior to letting the agent show his home. During the meeting, you build a good rapport with the homeowner, so you offer to be present during showings and negotiate the best price. A few days later, you're showing the property to his prospective buyer and her agent. They love the floor plan, the back patio space. You're hyping up the local shopping and restaurants. The next day, you get a call from the prospective buyer's agent with an offer. Excited to present the offer to the owner, you give him a call and ask if he could come over before you share the good news. What happens next? Who's responsible? You drove to the house and encountered a police officer leaving as you pull up. What happened? Well, the police say the thieves entered through an unlocked door in the back. You and the homeowner are thinking the same thing. Did you lock the door after the showing? No, so you were involved in a conversation where you forgot to lock the back patio door, and the homeowner says, I trusted you with my home and I'm holding you responsible for this. Who is actually responsible for the homeowner's damages and losses? So you didn't know you were going to be doing this kind of questioning, huh? All right, who's responsible for leaving the back door open? The buyer's agent should have made sure the doors were locked. The homeowner, there's no mention of an agency agreement, so the agents aren't liable. I want to say that one, because if you didn't sign no agency agreement, no. Okay, a position of trust. Okay, let's try it. That's what I would have thought. That's right. Okay, with or without a written agreement, you were placed in a position of trust. You left the door unlocked. You're accountable. Okay. So you got to be careful about that kind of stuff, because that kind of stuff does happen, by the way. This is why you got to have a little bit of insurance. Some error and omissions insurance. Okay, we are going to do the next one on the next video. We'll continue. So thank you all for watching, subscribing, and if you are continuing along with me, I'll see you on the next video.